Hi everyone, this is Professor Peter Sankoff. You're about to watch a portion of a seminar I did in January 2021 on the law of solicitor-client privilege. As you'll see in a moment, this seminar actually covered 6 different topics, and you're just going to be watching a few of the first 3. If you want to watch the rest of the seminar, you can do that by visiting my website at petersankoff.com. We regularly host a number of low-cost seminars designed for lawyers, especially those working in criminal or civil litigation. Hope you enjoy this video. Have a great day. All right, good morning, everyone. Welcome to our seminar today on solicitor-client privilege. Very pleased to see you with us today. It is the first seminar that we have done that's directed primarily to those who practice in civil litigation. There are we've done others that deal with both, and I could say that this will be of use to any type of litigator, but it is primarily directed to our friends who are practicing in civil litigation. So I'm very excited to be doing that. I thought we would begin just by doing the only thing we can really do today, which is acknowledging this is really, we're all just living in Bernie Sanders' world, and that's the way it is. So that is really the true meme for the day, of course. Feel free, as always, for those of you who haven't been here before, you can pose questions at any time using the chat function. If you have questions that you want to ask, we're a smaller group today. I expect people are going to flow in as time goes on, as usual, but feel free to ask questions at any time as we go forward. So just couple of things I would point out at the outset. As I said, since many of you are new, this is a 2-part seminar, and in a couple of minutes, I'm gonna show you what I am and I'm not covering in this particular seminar and what's gonna be covered in part 2 of this seminar. I honestly, after having gone through it for today, this could have easily been a 3-part seminar. There is more than enough to cover, but I've done it in 2, and it means I'm going to move quickly here. So again, ask questions if there's anything you don't understand as we're going. First, there is going to be a ton of information on these slides. And we do not send these slides out to everybody because it ends up being a big file. So I don't want to infuse everybody's inbox if they're not interested. Just make a note that to please send us an email, and we will send you the slides right after the seminar. So you can look at it as much as you like, okay? And as I said, please do not share these freely. That is true for the video recording of this seminar, which you will also have access to starting from tomorrow. You get permanent access to this video, so you can watch it as many times as you want. And I stress that that is a personal use only. There's a lot of work that goes into this, so please don't share with colleagues at your firm or whatever. We price this on an individual basis. So today's menu, let's talk about what we're going to cover for this particular session, and then I will, again, line up what we're going to cover in the next session. So today we're focusing on the following. First, I'm going to very briefly go through the importance of the privilege and talk about some of the theory that really drives all of the law in this area. I'm going to talk a little bit about how privilege claims arise, in what setting, and the way in which these particular claims are litigated. Talk about confidentiality and distinguish that from privilege, and also explain how it affects privilege claims. Then I'm going to distinguish solicitor-client privilege from litigation privilege, and I'm going to stress that in this session, I will not be talking about litigation privilege at all, except for the purpose of showing how something is not solicitor-client privilege because it might be litigation privilege. So I'm just going to distinguish that. I'm obviously, later this year, I'm going to do a couple of seminars on litigation privilege, but for now, I am just focusing on solicitor-client privilege. 5, then I'm going to look at what is the core of the privilege, establishing whether or not the communication was part of the lawyer-client relationship. And number 6, the last and probably most important criteria, whether the communication was made for the purpose of seeking legal advice. So let me stress that if you look at today's menu, this will deal with every aspect of the first part of the equation, which is, do you have a privilege claim? And how do we decide if you do have a privilege claim? That's it. Sorry, next month, we will look at the following. how the privilege gets lost. So we will look at the issue of waiver. We will talk about limited waivers. We will talk about state of mind waiver, which I'm guessing is going to take half the time because it's a really complex area. We will look at the loss of confidentiality through accidental disclosure. We will look about deliberate disclosure to an allied third party. We will look at the only real exception that matters. There are others, but I don't spend any time on them since they arise literally once every 15 years. Crime fraud is the only significant exception to the privilege, and we'll look about how statutes can limit the privilege and when they can do that. So that's all of the menu for February 26th. So that takes us to where we are today, and we've got a lot to cover, and I'm hoping it'll be of interest to you. Topic number one, how important is the privilege? Ladies and gentlemen, if you ever want to see judges speak and literally, like metaphorically, have tears running down their cheeks, give them a case on solicitor-client privilege. You've never seen that. The language is close to being Shakespearean, because when these judges have to talk about the privilege, what they end up doing is they're really, if you think about it, they're talking about themselves, the importance of the legal system. So nothing gets judges more jazzed up than talking about privilege. And I'm not kidding. You can go and look at all the historical cases, and they all start with the fundamental principle that binds the legal system together and makes it work is privilege. They will go on about this forever, and it's great and it's wonderful. As an aside, try to get them talking about any other type of privilege, and they talk about how unimportant it is and how it needs to be diminished and it needs to be, it's amazing. But lawyer-client privilege, that runs the system. And I'm not saying I disagree with that. I'm just saying, look at the language. So one of the most famous excerpts that's cited often is from Justice Major in the McClure case. And it's a really good place to start. And it's not telling you anything you don't know. But the reason that I'm emphasizing the language is the way in which we look through the lens of privilege is based on the importance that we afford it. So in other words, put it another way, we think privilege is incredibly important. So not surprisingly, we treat it as almost sacrosanct. And if you look at the language of this, I mean, look at that right away. Unique status, right? The important relationship stretches beyond the parties, and it's integral to the working of the legal system. So you compare that language to, like, personally, I mean, I'm an outsider on this, but honestly, I have always been amazed how in Canada, doctor-patient privilege is virtually non-existent. And it's like, I tend to think I tell my doctor a lot of really private things I don't want him sharing. And like, nonetheless, if push comes to shove, my doctor's going to have to give up everything. And I think that's problematic. But the point I'm trying to make is you see this language and you see how strong it is. When you talk about how it's fundamentally important, and of course, why, I'm not suggesting it's not. I'm just saying it is really, you can see words like the danger in eroding solicitor-client privilege is the potential to stifle communication between lawyer and client. As we will go through this, you will see that I think this has a real impact on both the scope of the privilege and the situations in which privilege will not be recognized. It all flows from the fact that it is so important that we both, you ready for this? It's so important, we need to always protect it, but we actually need to be careful about statements that go into it. And the reason for that is because it's so important, if we make it too vast, that's going to be problematic, okay? And that flows through all the case law. So let me give you some opening thoughts. Number one, the privilege is generally viewed expansively because we want to protect lawyer-client communications whenever possible. Therefore, the presumption lies in favor of recognizing it whenever you have a valid lawyer-client communication. The exceptions, as you're going to see next week, are regarded narrowly because, again, the privilege is so important, we don't want there to be many exceptions. The procedures place the onus on those who are seeking to have it set aside. So this is all really good for us, and as you can imagine. And it is also a principle of fundamental justice. So even statutory limitations have to be viewed in that context. If you have a security to the person interest, you can have the statute challenged for intruding on solicitor-client privilege. Very important to keep all these things in mind. Now, you might be thinking, well, it's so strong, it's so important. Why do we need a seminar on it, right? Like, why do we need a seminar? Solicitor-client privilege, sacrosanct, end of story. Well, it's not that simple, unfortunately, because here's the flip side. Number one, because it's so strong, there are criteria to satisfy for recognition. Parties overclaim. They do this all the time. So most of the litigation that arises in court about solicitor-client privilege stems from the fact that parties don't want to disclose information. You know that, all you civil litigators. That's the way it works. You don't want to disclose information to the other side, so you claim privilege over it. So it's important, obviously, for both sides to understand, number one, the difference between confidentiality and privilege, because they are not the same. It's also important as an advising lawyer that you can understand it and ensure that you activate it properly, because there are many situations when lawyers give advice thinking it's covered by the privilege and it's not, and that can become problematic for both the lawyer and the client. Just as well, you need to be able to resist claims that are trying to pierce legitimately privileged information. But if you're on the opposing side, you need to understand the scope and see the signs where the privilege doesn't apply. Because I'm telling you, I've read hundreds of these cases, competing sides will try to claim whole bulk of information as privileged when it's not. So you as the opposing lawyer need to know how to sift through the discovery, the disclosure, and the affidavits of documents to sift out which of these things are not privileged. Now, how do these claims take place? Because that's an important starting point to understand where and how this actually arises. Okay, you need to understand the procedural issues, and the best way to do that is I'm going to ask you a question, civil litigators out there. You're the opposing party. You become aware of privileged communication. It's relevant, seems to clearly be relevant to the dispute you were involved with. So tell me which of the following of these is true. By the way, B should be on demand. I don't think it has to be produced. I'm just saying on demand, okay? So don't say, well, it doesn't have to be produced. That's true. On demand by the other side, okay? What do you think? All right, most of you have voted. And not surprisingly, as with all things privilege related, the answers are all over the map. So these are the answers. We got a little bit of everything, and I'll go through each of these to explain why they are right or wrong. Although I can tell you that, to my mind, only D is correct. Okay, D is correct because D correctly states the evidentiary foundation required and the way we approach the privilege to begin. And I'll explain that in just a moment, but I'll go through some of these answers. The balance of privilege and non-privilege is taken very seriously by the courts, but some of these answers go way too far. So A, for example, it is not correct. The privilege is so important that judges will not ordinarily produce it for review. And in fact, there's case law saying that judges shouldn't produce it for review unless there's reason to do so. So A is just not correct. It does not get produced to the judge. And for the same reason, B is not correct, because you just don't produce the statement at first instinct. That's actually a last resort, not a first resort. C goes way too far. The party claiming privilege does not have to produce details about the nature and extent of the communication, and as you'll see, the courts feel that doing it that way would effectively give up the privilege. Like, the whole point of the privilege is that you don't have to turn anything over or reveal it. So if you had to reveal it every time, that would weaken the privilege. So that's too far. And E is just too far the other way. The fact that it's relevant, supported by some evidence that it's a communication between a lawyer and a client, like some evidence, that's generally not enough. There's got to be a little bit more if there is a situation to believe that the privilege might not apply. And D correctly sets the balance between the two things. I'm going to sum it up for you. Here's the summary statement, although I'm going to get into the details in just a moment. Privilege will be maintained, are you ready? Unless there's some reason to believe the privilege might not apply. And then, At that point, the trial judge might want to hear submissions and look at the material. But the basic bottom line is just asserting that, well, we need to see this, it's relevant, it's important, not enough. There has to be some reason to believe why the privilege might not apply. So let's delve into this particular issue in some more depth. Okay, topic number 3, confidentiality and privilege. I know, it's a cute little meme. Look, it's amazing how many people think confidentiality and privilege are the same thing. So I always start off a discussion of this type by reminding people that everything that goes into a lawyer's hands is confidential. That's just the way it works. But not everything that goes into a lawyer's hands is privileged. And that's just, you know, first of all, it's straightforward, but the duty of confidentiality is set out in the rules of ethics in every province. And that imposes clear duties on turning stuff over. So let me be clear. The main difference between confidentiality and privilege, which should be obvious, is that you are under a duty to hold everything confidential. You are all the time. So you should never reveal stuff that deals with the solicitor-client relationship. However, in the rules of ethics, it clearly says, unless ordered by law. So the unless ordered by law part is where privilege comes in. Like essentially what privilege is about litigating situations in which confidential communications do not have to be turned over. That's what privilege claims are. So don't be confused about the two because they're very different, even though confidentiality is a core component of the privilege. I actually think those issues are not complicated. I think where it gets complicated, isn't that a cute picture? I worked hard to find that one. That's the real issue because, like, you know, I'm not talking about situations where you have an overheard. Let's just leave aside the issue of a client, of a person overhearing. What about the situation where another person is present? That to me is a more complex situation that we need to examine. And this picture sets it up. Two's company, but does 3 automatically make a crowd? And the answer actually is no, it does not, as you probably know. The way this gets dealt with through the courts is through something called common interest privilege. And there are a few things in the evidentiary universe I hate more than common interest privilege. Really, honestly, I really have to work hard. Some of you who've been to other seminars know I have bugaboos, but common interest privilege drives me crazy. And I'll tell you why. You ready? It's not that complicated. Judges cite common interest privilege as if it's a thing. There is no such thing as common interest privilege. It doesn't exist. There is no, you don't have a privilege because you are common in interest with somebody. Like, you follow me? Like the privilege, there is no such thing as common interest privilege. 2 parties can get together and have a common interest and have all the discussions in the world. They are not privileged. Common interest privilege exists exclusively in one area. Solicitor-client privilege. That's it. It is a fiction that judges treat as having its own criteria. It's just nonsense. It doesn't make any sense. What does exist is solicitor-client privilege. And if you drill down, I promise you, on every case that uses the term common interest privilege, trust me, read it carefully, you'll see what they're talking about is solicitor-client privilege. And what they are really talking about, and in my book, I deal with it exclusively this way. I refuse to acknowledge, I'm not an idiot. I acknowledge that judges talk about common interest privilege, but I frame it as this. It's a way of expressing the fact that solicitor-client privilege can exist even though you don't have confidentiality. Got it? That's really what common interest privilege is. You have, remember those 3 parrots? Like, the only question is, does that parrot have a common interest? And if they do, then you still have confidentiality, because confidentiality is an absolute requirement of the privilege. That's what common interest privilege is. It operates in any situation where a so-called third party shares a common interest. And it works as follows. So pay attention. I got these handy dandy diagrams. You ready? You like that? Lawyer says otherwise. You notice how the person's saying otherwise privileged communication? So we're just going to assume that all the other requirements of the privilege are met, because all we care about here is confidentiality. Everybody with me? So when this communication is made, right? This person is present. That's the only issue. And you notice I've included the world to differentiate between the different statuses of this person and the rest of the world. So I'm going to go through every situation. You ready? Here's the situation, the first one. Is it privileged? That's the only question we need to know. And remember, all the other criteria of the privilege are met. So the only issue is there confidentiality? Everybody follow me? Because that's all that matters. There is a third person in the room. Is it privileged? One, the first situation is there is no common interest when the communication is made. So this person, whoever it is, obviously does not work for the lawyer, obviously does not work for person A, is just a person who they go together, but they're already having issues at the time this communication is made. But they decide to go see a lawyer and think maybe this lawyer, right, can help us settle our differences. But it's clear they are not common in interest. Well, how does the privilege deal with that? I hope you all recognize, having done what we've done thus far, there's no privilege. The privilege doesn't exist. There's insufficient confidentiality. You don't have a confidential relationship between these two people. So as a result, there is no privilege at the time of creation. So let me say that whatever else happens, are you ready for this? If B wants to use that communication against A, no problem. They can. There is no common interest. And you ready for this? It gets worse for person A. By the way, this is why you are very careful about having multiple party communications. You've got to be really clear that those interests are aligned, because the rest of the world can use that communication too. If B comes and says, you know what, screw you, A, I'm going to go tell the rest of the world about this communication. And A goes, wait a minute, it's privilege. And the rest of the world goes, oh my God, we can use this against A. A is out of luck. Like, that's the way it goes. There is no privilege at the time of creation. So as a result, this material is now usable by the rest of the world. That is pretty rare, as long as lawyers are very careful about dealing with multiple parties. What is more common is that there is a common interest when the communication is made. Now, if that interest continues throughout, I'm sure you can recognize that the material is privileged. There's no problem. The fact that there are three people, that is what common interest is designed to do. They're all working together. There is no problem. It's maintained. No one can use it. Now, those are two situations. There is a third. Okay, you ready for the third situation? The third situation is slightly different, because in this situation, you have a common interest when the communication is made, but that interest breaks down. Okay? This is, you want the easiest version of this, ladies and gentlemen? I'll give you the easiest. You ready? They're married. That's the easiest. So they go see their lawyer to make a will. And A says, I'm stealing money from the government, blah, 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 blah. It doesn't really matter what A says. Otherwise, privileged communication. They eventually break down. So the question is, once this interest breaks down, what happens to the privilege? That's where common interest privilege gets interesting. Number one, the privilege is partly upheld, and I hope you can see why. Here's how it works. The privilege can never be upheld against person B. Never. Because person B was in the confidential circle. So if B wants to use that to show why person A should not have access to the kids, she can do that. So let's assume for the moment that the otherwise privileged communication is, by the way, lawyer B, I'm smuggling drugs for the drug cartel, okay, which, believe it or not, is privileged, even though, don't trust me, it's privileged. I'm smuggling drugs for the drug cartel, and I want to know, if that's going to cause me problems down the road. Okay, great. Now she wants to use that statement as an admission. She even wants to call the lawyer to testify to it, to say, do it. Can she do that? Yes, because the communication was not confidential. I know that seems weird, but if it makes perfect sense. Look, the communication was not confidential when it was made. So like she was there. So she's entitled to use it to her event. However, you ready for this? The rest of the world cannot. That's very clear, because the privilege still exists within this three-party trio. And note the key. Do you notice the different situation? The difference between situation 1 and situation 3 is that in situation 1, there was no common interest when the communication was made. Whenever there is a common interest at the time of making the statement, the fact that the parties break down later does not mean that the rest of the world gets to pierce it. That would be unfair because this was a valid communication. It was confidential, but it can never be upheld against B. And that is the way common interest privilege works. Therefore, as I'm assuming you can imagine, do you want to know what all the jurisprudence around common interest privilege is? How do we determine whether the two parties are in interest at the time the communication is made? That's where all of this gets interesting. So let me ask you, you're all the smart people out there. What's a common interest? Well, if you'd like the answer to that question and a thorough review of the other topics on today's menu, you can see the rest of this seminar by visiting petersankoff.com. Don't forget that part 2 of this seminar is coming up in February. In that, we're going to look at the law governing waiver and a host of other important topics. If you want to learn all you can about the complex areas involved in solicitor-client privilege, visit petersankoff.com and get everything you need to know about our seminar series.